Watch out for using drugs, and that happens to be our topic for tonight.
Oh, come on. What's a little drugging for sex? Come on.
Well, this is the thing.
Foreplay.
This is one of the things we want to talk about, is that there's, things that are called date rape drugs, but then a lot of these drugs that are called date rape drugs are actually recreationally used now.
I know. So here's the thing. Drugging's bad, okay? I'm not promoting it. It's very
drugging
bad.
yourself, drugging somebody else, especially even worse.
It's
right?
bad. It's bad. It's bad. I'm just doing a parody about it because we just won a case where the client was alleged to have drugged the victim, complainant, and we focused in on the drugging.
You just called her a victim.
I went right after that because there was no evidence of drugging. Toxicology came back with no substances. They were remotely close, nothing, zero. And in cross-examination, the complainant had said, when I had drank whatever it was, which was water at the time.
Tasted like water, smelled like water, looked like water.
Clear, water.
Water.
I felt fine. I didn't feel anything, but I have no memory for 45 minutes. I passed out.
3 seconds.
That's right.
Right? She's watching the water being poured. She's watching the water being poured right in front of her. It's set right in front of her. She says she turns to the side and looks down underneath the counter for 3 seconds, maybe 4 max. Agrees she would have seen if he picked up the glass, but disagrees that she would have seen if his hand actually moved over and put something in the glass.
And that was the only opportunity for a drug to be administered to her. That was the only opportunity. And then she agreed in cross-examination that she had felt no onset symptoms of any type of drugging. Just it passed out.
Went unconscious.
Happened instantaneously.
Within seconds.
You're laughing. That's the f***ing evidence.
And woke up only about a half hour later. So this is
for some reason.
And this is one of the things that the judge pointed out. It's like, I'm trying to think of a drug that would act that fast and disappear from your system. Because she went
about
to the
4 to 8
hospital
hours
and had blood tests done 4 hours later, and there was no evidence.
And urine analysis.
No evidence of any drug. Apparently totally cleared the system. But a drug so powerful that it completely knocked her out unconscious within seconds. All right. Thankfully, the prosecutor, which in Canada we call the Crown, admitted that he does not know of a drug that would do that.
Kudos to him. Great guy. Very fair.
Mm-hmm. And
but
that is...
I want everybody to think about this, okay? So let's set this up. We started off a bit dramatically right now because we're stressed about stuff. But, okay, so this is a case where this fellow wound up having this young lady in his home. And for whatever reason, they wound up...
For whatever reason, people are wont to do so.
Yeah, for whatever reason, they wound up having intimate contact. And she accused him of sexual assault, and she said
it's a dangerous venture nowadays to have a young woman in your home.
Indeed it is. And she said that, he offered her alcohol, and she said no, so she didn't drink any alcohol at his house. But she did ask for a glass of water, which was provided to her. His hands were in front of her. Poured it from the tap, put it out in front of her. For some reason, she was distracted to look down, as you said, for 3 seconds, and picked up the glass and drank half of it or less than half of it, and then instantaneously was out, woke up 30 to 45 minutes later with no memory of
in a
what
bedroom
happened.
That was pitch black, but also sometimes had light, depending on when you asked her a question.
So we want to focus on drugging. We won, but I can tell you this. Our client testified very well, and we spent time with him because people don't know what it is to be in a courtroom, okay? But
they just think, I didn't do it, so obviously I'll just gonna say I didn't do it.
Yeah, again, I say this in every podcast. I get calls all the time. Oh, there's evidence that I didn't do it. There's no evidence. She's just saying I did this. That's evidence. You can be convicted on that. Leave that alone. You have to testify in your sexual assault case. You got to do well. But let's focus on the drugging. The whole point of this episode...
Can I just pause for a moment, Joseph?
Pause. I will pause.
You forget, because you're an officer of the court and you've been doing this for so many years, you forget how scary it is for people to go in and testify and be in a courtroom where there's a person on a pedestal who can send you to jail for a number of years. And you're just like, just go in there and,
No, but I do. We prepare them. We spend countless hours with our clients preparing them.
I know, but but at the same time, it's like, like people like literally be shaking.
And I'm yelling at them in preparation.
I know. It's just like,
but I got to get them ready.
I know. That's important though.
I got to get them ready. I can't pussyfoot around this. You've got to be able to testify. If you can't testify, you're going to get convicted. And there's no way to win one of these cases if you don't testify, unless you blow the complainant out in cross-examination, which is a rarity, because the presumption is they're always telling the truth. Oh, that inconsistency isn't that significant. This inconsistency isn't that significant. The fact that they forgot the date, time, and the contents of the sexual assault, not that significant. Like, me. You need to testify. You need to testify. Is that the right camera? You need to testify.
But what's the problem when both parties are doing drugs that affect their memory? What's the problem?
Then you're because if the accused is going to testify, yeah, I did drugs, I drank a lot, I don't have a lot of memory, your evidence is like gone.
What's the point testifying if all you can say is I don't remember what happened?
No point. So don't get in the stand and say that.
But then
don't.
But
you got to remember something.
But we have this problem now where people are recreationally taking GHB, which is noted for causing memory loss. They're taking this for fun.
But both parties are.
And then, there's an issue when people are actively choosing to take, male and female, choosing to take GHB and apparently ketamine, which is growing in popularity.
Yeah.
And that's just mind-blowing.
It's an animal tranquilizer, eh?
I know. Well, I guess you could take it in different doses. I don't know. But this is like a growing recreational thing that people do.
But a lot of these people do it together.
These drugs are actually called date rape drugs.
Yeah, I get it. But they do it together.
I know. So then...
We don't often have cases coming out where people get together and they decide to do drugs together. We have this... The drugging in this case is about somebody who's covering up a lie and says I was drugged in order to overcome their absence of a story here.
Okay, and let's actually, before we get into this amazing article that I still remember because it was so interesting.
But set up for everybody.
The case that we're looking at is really interesting because the Crown does not have to call expert evidence.
Take all this slowly so everybody understands how insidious this can be.
So normally if you're being accused of having drugged somebody and then sexually assaulted them, using the drug to commission the sexual assault, to facilitate the sexual assault.
Right.
Normally you'd be charged with sexual assault as well as administering a noxious substance.
Correct.
But quite often there is this vague implication that they think they might have been drugged because they felt dizzy and a little bit woozy. But they don't know if they were drugged.
And they can't really remember what happened.
They can't remember anything. And all of their senses are out. And so their memory is not really trustworthy. And therefore they don't have to be consistent.
But I didn't consent. And I was sexually assaulted.
But they know they wouldn't have consented.
Right.
And this is a weird thing too. Is because, it's like you can't really talk about... Well, you wouldn't have. Well, then you would think that would open up to defense to say, well, actually, we happen to know that you've consented to sex under these circumstances so many times. No, that would be prior sexual history. We can't bring that up.
Right.
But they're allowed to say, no, I know I wouldn't have consented because this isn't the kind of person I am.
That's absolutely correct. That's admissible.
Yeah.
Go figure.
It's been tested a number of times, and they've said, when their memory is really poor, they're permitted to talk about what they would or wouldn't have done, but we're not allowed to then bring up evidence of other people they've had sex with under similar circumstances, because that would be a rape myth.
So, this way of running a prosecution allows the Crown to proceed with allegations of drugging, even though there's no evidence. So we can say there's no evidence. So there's no toxicology. So if there's any blood tests or anything of that nature, nothing in it. Zero supporting evidence. But they can still say, I was drugged. That's essentially what they're saying.
And the Crown doesn't have to prove they were drugged. The Crown can just imply it.
Well, right.
Because they're relying on the
but it does
evidence.
become a cornerstone of their case. If the complainant is saying, like in our case, which we won, that I went unconscious, I have no memory until I woke up at this time, it really is a major factor in the case.
How did that happen? Because there wasn't alcohol, like unlike some other cases too, there might be excessive drinking of alcohol involved. In this case, there was no alcohol.
Other drug use.
Yeah.
Right. There's nothing.
Yeah.
Zero. So there's no other alcohol, no other drugs consumed, nothing. It was just, I had this bit of water where for 3 seconds I was looking down for some reason, but I had peripheral vision, and then I'm out. So you drill in on that fact, which is a foundation for the allegation. As I called it in submissions, it's a pillar of the prosecution's case. And we won based on that and also our client's evidence. But we want to talk about this ability to marshal an argument about drugging where there really is no evidence about it and there's no charge of administering a noxious substance. It is really dangerous.
And, I just want to throw out there, people always say, and they're not allowed to ask this in court, but in the court of public opinion, they always say, why would she lie? Well, if you say you were drugged, that means you don't have to remember anything, and you can just say something happened without having to actually explain it in detail. You can't be questioned on it anymore.
Right, so you thwart the ability to be cross-examined. It's an easy way out. If you're going to make up a story to cover up something and you want to charge somebody, that's a great way to do it.
And you don't want to admit to things that you did and said?
100%. 100%.
What was being said? Nothing. I'm sorry, you woke up in the middle of a sexual assault and managed to get out of the room without this individual saying anything like, oh, hey, you're awake. Oh, hey, don't leave the room. No effort to stop her, nothing.
Well, that was the facts in our case.
It still disturbs me, though, that was never addressed properly, because you're telling me that somebody's going to go through the effort of drugging you and then make zero effort to stop you from leaving?
Okay, so let's frame this a little bit. So in our case, the complainant said when she woke up, she was able to just shimmy her way off the bed.
That was the word, shimmy.
I used that. I like the word shimmy.
No, that was her word.
And poppycock, and get off the bed, and the client of ours didn't say anything or try and restrain her in any way.
Not a single effort to stop her from leaving the room.
Nothing. And, it wasn't addressed by the court as being a factor that deterred from her evidence because, well, that might be a factor of being drugged.
Which she was found not to have been.
That's the problem I have with this. So you can mask inconsistencies or lack of evidence or explanation about logically how you got out from a situation, how you extricated yourself from this situation by masking it with this drugging allegation. So that's the core of it. It's dangerous. And if not for drilling down on this very well in trial and having very good evidence from the client, somebody could be convicted on this.
Now, you tell
without evidence. No expert evidence.
Well,
nothing. You could call an expert. The Crown can call an expert to say, well, there are drugs that metabolize really quickly. They can affect this way. There is none. Zero, nothing. No expert evidence.
That's what I was going to get to. So what do you do when the Crown calls an expert about drugs, but there's no specific drug tied to that particular allegation, yet the Crown, as I've seen happen, will call an expert to testify about what drug could have been used?
But then you cross-examine, you go, that's exciting. My favorite line. But here's the facts in our case. So what drug would fit this scenario where it can happen instantaneously with no metabolites later on? And they'll go, I don't know any. Well, thank you.
But
Goodbye.
Let me tell you about ketamine.
Right.
No, I've seen that happen.
But there's a reason. There's no expert evidence in this case because there's nobody who could support this fallacious bullshit allegation of drugging. Right. But it could have led to a conviction. And this is not the only case. This happens more often than you think. But there's an interesting article, right?
There's an interesting article by the late great Christy Blatchford. Was a dear friend of mine, and we all miss her. She was one of the top crime reporters and court reporters in Canada, and she held them to account, man, because she was sitting on that trial. The judges were.
She called strikes and strikes and balls. She called them. She was great.
So this is an article from the end of 2018, not too long ago, but it stood out in my mind because it was a really intriguing one where she's going, what do you do in a case where somebody admits to having, a female complainant admits to having taken GHB of her own volition, and of course she has very little memory, and then so she was talking about the difficulty this presents in court, and that she says, sorry, this is printed on 2 different pages. It goes on for a while, so I'm trying to skim read it a little bit to save all the details and stuff. But she took it voluntarily, the young woman said, because she had to go to work at her second job in a couple of hours and thought it might help her relax and sleep. Yeah. Instead, the prosecutor said, in the early hours, the woman found herself naked on the bed having sex, even participating in it. So she recalls when she woke up that she was actually participating until she realized it was with that particular defendant. And in this particular case, I love this too, because Christy didn't name the defendant because she respected his privacy as well.
Which is amazing.
I know.
Good for her.
She said it felt dreamlike to her.
May she rest in peace.
I know. And the complainant said, I wish it was a dream. And she was nearly in tears in cross-examination. She acknowledged having 10 drinks, snorting 4 or 5 lines of cocaine that morning, as well as taking a shot of GHB. And she agreed that she suffered memory loss before while drinking, most often in the last hour of the long night, and that she had lost as much as an hour of the night, which she doesn't remember, but she was acting voluntarily. So the big question here is, what do you do with that when somebody is saying they don't have memory, but they think they would not have consented, and yet we know that when you intoxicate yourself and take other types of drugs, you're more likely to do things you wouldn't normally do.
I got to tell you, if this case was litigated now, he'd be convicted.
The interesting thing is
because the onus really is on the guy to recognize when she's incapacitated, whether it's from alcohol or drugs or a combination thereof. Mm-hmm. If this was litigated in 2023 or 24, not 2018, he'd be f***ed.
Right. Well, the interesting thing at the end of this, and there was an expert witness and toxicologist who told the jurors that the typical profile of what's called a drug-facilitated sexual assault is either someone's drink has been spiked or they drink until they pass out.
She took this voluntarily. And in fact, she said something curiously. She admitted she was curious to hear the defendant's side of things, but whatever else, the encounter was nothing she ever consciously wanted. Okay, yeah, but she wanted to know what his side of the story was.
Because she didn't know what actually happened.
But she took the GHB. Like with everything.
Mm-hmm.
There's a whole sidebar to this I got to talk about in a moment, but he would be convicted now. Because the concept of capacity has changed because of the Court of Appeal decision.
With the very end of this article, she says that that the defense lawyer actually didn't call any evidence because he said there was no case to meet. So what does that mean?
It means he would lose now.
Nowadays. So no case. Excuse me. So when you say there's no case to meet, that follows the principle that the Crown has to, or if you're not in Canada...
Yeah, give the burden.
That the prosecutor has to present their entire case first before the defense decides if their guy's going to testify or their client's going to testify if it's a female. You don't have to call evidence in the defense until the Crown has created a case to meet. If the Crown calls all of their witnesses, presents all their evidence, and what they presented doesn't actually amount to any proof of a crime, you just go, I'm sorry, bye-bye. I don't have to say anything. But
you'll lose.
But it's a very low standard to say whether or not there's a case to meet.
Okay, so there's 2 aspects. After the Crown's case, you can bring a motion for directed verdict of not guilty, like a non-suit. That is the threshold that there's no evidence the jury reasonably instructed could return a verdict of guilty. It's a very low threshold. It's like stepping over your baseboard.
If you could. And in general, all you need is somebody to say is, I was sexually assaulted, and then there's a chance that you could be convicted.
And in this particular case, if the person says, look, I was drinking, I was intoxicated, we were having fun, he offered me the GHB, I thought, okay, I'll take it, but I don't remember what the fuck happened, and I wouldn't have consented to it, that's going to be enough evidence to get over a directed verdict. In this case, the defense lawyer may have, at that time, said there's no case to meet here because there's no direct evidence of her not consenting. Okay? So the Crown bears the onus of proving beyond a reasonable doubt that the complainant did not consent to the sexual activity.
It's a whole bunch of legalese, which, if you just play it on slow, you can work it out.
I know. But also there's capacity. In this case, was the complainant having sufficient capacity? Consent. Okay? So there's really 2 aspects. Nowadays...
Well, how do you know if they had capacity is basically subjective. They could say, well, I didn't know what I was doing.
Well, it's the amount of alcohol she's consumed. They had a toxicologist testify.
Mm-hmm. But alcohol affects different people differently.
Well, you can cross-examine on that. But we know the test now from the Court of Appeal is that it's not just about rudimentary activities you can perform. So walking, talking, making a joke, using your cell phone, you have to have some conscious awareness of what you're doing and the consequences of engaging in the sexual activity. That's a much higher standard, in my opinion, than what it used to be. We used to call it drunken consent is still consent. That's been like pissed on, and that's not the language we want to use.
It's still upheld in Already.
It's still upheld, but they still want you to have, the complainant has to have some conscious awareness of what they're agreeing to. Okay? Fine. In this case,
they have to understand it's sexual in nature. They have to understand that they can say no. They have to know who they're actually having sex with.
Right. You may think you take it for granted, but it can be an issue.
Yeah.
But it's a slightly higher standard now.
I think the most important one now that was kind of added in recently was they have to understand that they can say no.
Right.
So
one would assume that would be like a given.
When people say, it was like, well, I just froze, because that's a really common thing. So I just froze. I didn't know what to say. I wanted to scream, but I couldn't. And so that equates to not understanding they can say no.
Right. So in that case, you can't say, there's no case to meet, I'm not calling evidence. So that's different than a directed verdict. The accused stands up in front of the jury, and or the lawyer stands up and says, I'm not calling evidence. There's no evidence for the Crown in this case, or evidence for me to meet.
There's no case to meet, yeah.
Which is stupid, because the jury is going to have to rely only on the evidence of the complainant. That won't fly anymore. That's not going to fly now.
The reason I bring it up is because how many times do we have people show up here saying, I don't understand why I'm charged because there's no evidence.
I can't anymore.
I know we've talked about this
I'm
a lot,
losing my mind. It's every week with phone calls. I have evidence that I'm not guilty. She didn't say no. There's no other evidence. There's no video of it. I'm like, dude, that's not the law here.
Their testimony is evidence.
Their evidence to the police is enough to get you charged. At trial, their testimony is enough to get you convicted. That's evidence.
And even if there's no evidence of a drug, they can still go forward to trial, and they will go forward to trial because the complainant's going to testify that she felt drugged.
That's the point of this episode. Yeah. It's insidious to say that you were drugged. It's insidious to also say, I voluntarily engaged in drinking and taking a drug to either enhance my experience or do whatever, but I don't think I would have engaged in this. I need everybody to pause for a second. Where have we come now?
Well, women fought for the right to, live dangerously and make choices, and now apparently they don't want to be held accountable for it. So
we talked about,
that's where we're at.
3 years ago when we started this podcast, about the government getting out of our bedrooms. Okay? The government's in our bedroom. So they legislated, don't vilify me for this, okay? In the criminal code, if you're unconscious, you can't consent. Okay, I get the concept, okay?
Because you can't say no if you just suddenly were to decide that you didn't like what was going on.
Right.
That's the reasoning behind it.
But couples, including married couples, might enjoy that type of activity, being woken up with a blowjob or with something else.
But this is like, just separate it out, because this still bothers me. That case, J.A., had to do with a woman who agreed to be choked until she was unconscious. And that was a BDSM type activity where she then became actually unconscious, not just asleep, but actually unconscious. And then she said later, I was like, yeah, we've done that before. I was okay with it. But the Supreme Court said, no, you're not allowed to consent. That is different.
No, it's not.
Than somebody just being woken up. Because
no, it's not.
Because
you may have an agreement. You may have an agreement in your relationship.
She couldn't wake up in that case. She couldn't wake up because she was choked unconscious.
But that's what she consented to, and that's what she wanted. That's what she wanted. The government is in our bedrooms, okay? And they're dictating what we're allowed to do and not allowed to do. This was a podcast we did 3 years ago. So if you have a relationship that's consensual, and one partner says, I'd love to be woken up with some touching and intimate behavior, that would be great. That's like a fantasy of mine. Can you please do that? The government,
little sexy voice cracks me up.
I'd really like that. That'd be great. I'd really enjoy that. That would be orgasmic. The government has told us you can't do that. Stop. The government has said that's illegal. It's in our criminal code. Yeah. If you're unconscious, you can't consent. Thereby, it's a sexual assault. So you're hoping your partner doesn't go to the police, even though that's part of what is enjoyable for your relationship.
I believe it's also illegal to take GHB, and yet complainants can say they did that, and there's absolutely zero consequence for them.
But that's the point. So let's take it to another extreme. Some people want to get intoxicated together. Some people might want to take drugs together, like GHB, and enhance their experience to whatever they want.
I can't imagine.
The government has said that that is illegal.
I just don't understand why you want to take a drug where you won't remember how much fun you had.
I understand, but think about this for a moment.
How that works.
And then if something goes sour in your connection with this person, then you go, well, you know what, I did take it, but I don't remember, and I wouldn't have consented. It's so f***ed up because now we can't even get into the history of what you do by way of a relationship, because that would mean because you agreed to have sex on drugs this time doesn't mean she would have consented that time. It's a nightmare now, because sex isn't the 50s of what the concept of what sex is. That's not the concept. People enjoy things in very different ways or different methods or different combinations thereof. Rock yourself out, but the government is in your bedroom. And things can go awry very badly when people are aggrieved out of relationships, and can go back in time and say, all this happened to me, including I took a drug, but I didn't really want to, or I did, and I didn't consent to this because I would never consent to that. It's very dangerous, especially without evidence.
I'll get stronger. I think it's nefarious that the Crown can
Ooh, nefarious.
That they can try to prosecute somebody on the premise that a drug was given without any evidence of a drug.
Do you think, Diana, that the prosecution should not be able to bring a case if there's not toxicological evidence of a drug?
I think they should be barred unless they're charging with a noxious substance and they are actually trying to make a case that the drug was administered. I don't think they should be allowed to.
But should they not have then some scientific evidence of it?
Well, you would hope so, because they have to prove the noxious substance first, and if they have no evidence.
When this podcast airs, what do you think? What do you think? Do you think that the government has a right to bring a case if there's no scientific evidence of it? Because, look, frankly, it's going to be gone in 12 hours. Lots of drugs can metabolize within 12 to 15 hours. It's gone. Okay? So if you want to bring that case on a week or 2 weeks or 3 weeks later, there's no ability to test for toxicology at that point. But I think it's a fair point.
Yeah, I just don't think that it's fair to have an implication of something without directly making the accusation in court. And that's how I see these things play out so often. If you're going to do it right. You know, like if you're going to charge somebody, charge them for what don't just imply it.
So what you're saying is, so let's circle back for a second. Let's close the loop on this. So what you're saying is, if you're going to charge about drugging, if that's going to be part of your narrative of the sex assault, charge also with administering noxious substance. Let's be out front about it. Let's litigate on that issue.
And if you don't win on that charge, then you can't use that to try and get around the back door for a sexual assault.
Okay, I agree with that. Until next time, I hope you enjoyed this podcast. I'm going to say it in my voice. If you do like the podcast,
sexy voice,
can you please don't forget to like, comment, subscribe, and share. Good night, guys. Thank you. Welcome to 2024, motherfuckers.